Hey YouTube, the Alien Enemies Act. This is Ben Barr, your friendly constitutional litigator. This week we're going to examine whether President Trump's use of a rather dated law, the Alien Enemies Act of 1798, comports with modern notions of rule of law, First Amendment, and due process concerns. Now, as always, I offer deep dive videos. We're going to spend time working through the nuances of the law. So if you're looking for a video that simply sides with President Trump or one that shouts up and down that fascism is here, this isn't the place for that. But if you want to explore some of the deeper issues, we're going to get to that today, where President Trump might be in his highest level of legal strength to act in this way, and where potential weaknesses are opening up. At the end of the day, I can tell you this: the summation of history in court cases on this topic suggests that the Constitution has two things to say to those violent criminal members who have been deported. Adios, muchachos. Let's jump in. So the Alien Enemies Act of 1798 is one of our nation's oldest security laws. It provides that it authorizes the president to apprehend, restrain, secure, and remove any male 14 years or older who is a citizen or subject of a hostile foreign nation whenever there shall be declared war or any invasion or predatory incursion. What does that all mean? Now, a lot of the legacy media that's reporting on this seizes on the first part of the end phrase, that there has to be war present. But the Trump administration rightly points out that the provisions here detail was something more than just war. There would have been a period after that word if that was the only time in which the president could authorize this power. So we have invasion or predatory incursion. As an originalist and as a textualist, what I would be concerned with is, what does something like a predatory incursion mean at the time of our founding? And I think we can go back and find several examples of its usage in two different distinct areas. One area that we think of is the high rate of pirates that America had to deal with. So piracy during the founding era and the use of quasi-military force to go after hostile actors. We're not necessarily at war with a particular country, but we're using quasi-military force to go after pirates. Other ideas might be thinking about Indian Native American skirmishes in the early days and use of similar powers as well. Now, I think most folks have covered this, but there's been three usages of the Alien Enemies Act in our history, and with very little corresponding judicial treatment. So we're just going to go over those quickly and move on to some deeper issues. During the War of 1812, President James Madison invoked it. After Congress had declared war on Britain, all British nationals in the United States were ordered to register and report their personal details with the government. This was used to monitor enemy aliens rather than to expel them in some way en masse out of the country. Now, President Woodrow Wilson, following the 1917 War Declaration for World War I, it was applied, the Alien Enemies Act was applied to nationals of Germany, Austria, Hungary, the Ottoman Empire, Bulgaria, and close to 500,000 Germans were rounded up and several were arrested. They were interned in camps under this authority. Franklin Roosevelt, FDR, used the power after the attack on Pearl Harbor, and he used it against Japanese, German, and Italian nationals in the United States. These alien nationals had to register and were subject to curfews, travel restrictions, and internment if deemed dangerous. Now, this is different than what we popularly think about during this time, the Japanese internment Korematsu case. That relied on different statutory authority, but we did have sort of broad-ranging restrictions on alien nationals during that time of war. So one of the things that we can just start off with that's novel about President Trump's use of the Alien Enemies Act is that no other president has tried it when there was not an official declaration of war. But here's a rub on that. America hasn't been in a war since 1942. Not formally. We've stopped declaring We've stopped making formal declarations of war. This is a whole area of niche constitutional debate and legal controversy in and of itself. So it shouldn't be too surprising in that sense that maybe it hasn't been exercised as regularly. End of the day, no president has tested the alternative trigger, invasion or predatory incursion. Now the Trump administration is, and the courts are going to decide what to do with it. Let's start with President Trump's strongest existing judicial precedent that suggests he can use this power outside of war to be able to detain and remove violent foreign criminal gang members. So we look to President Truman after World War II and the case of Ludecky versus Watkins from 1948. The Supreme Court upheld President Truman's post-World War II detention and removal of a German alien under the Act. Now, active hostilities had ended. The German petitioner had argued that the war was over and the Act could no longer apply. But the Supreme Court deferred, there's that word again, entirely to the political branches on the question of when wartime emergency powers expired, and that there was a reasonable argument to be had that even if the war had formally ended, we still needed to deal with foreign enemy agents in the United States. So the Supreme Court upholding President Truman's use of this extraordinary power just demonstrates another trend that we've shown in many of our videos. It's that D word, deference. So the court is not going to second guess the president's use of the Aliens Enemies Act authority so long as it feels that its predicate requirements have been met. So one can argue that if the president proclaims an invasion or some predatory incursion under the act, the court may very well view this as a political question where the president is owed great deference and the court will only intervene when the most outrageous constitutional violations seem apparent. As we noted in the Khalil video last week, courts have thoroughly recognized the plenary power of the executive and Congress to some extent over immigration and deportation matters, especially when they're intermixed with national security. In Nauf v. Shaughnessy, the Supreme Court famously stated that the power to control or expel or exclude aliens is fundamental sovereign attribute, and it's largely immune from any sort of judicial control, especially when exercised on national security grounds. Supreme Court also has held in Matthews versus Diaz that the Congress and the executive branches can draw distinctions in immigration and deportation matters that would be unconstitutional if applied to citizens, due to the fact that we give great leeway to these branches to decide how to handle foreign nationals. This bolsters the argument that the president can lawfully invoke these sort of dormant emergency powers without an actual declaration of war, so long as Congress has not forbidden it. So the strongest foundation for using the Alien Enemies Act without a new declaration of war is being very focused on the precise language of the statute itself. When there has been a proclamation of an invasion or predatory incursion, the president is authorized to take swift measure to remove these sorts of violent individuals, threatening individuals. So does all of this mean it's an automatic win for President Trump? No, because we have so much more to explore. Due process concerns emanate all of this. So under normal immigration law, Immigration and Nationality Act, for example, non-citizens, even those here unlawfully, I know you don't want to hear that, are entitled to certain procedural safeguards, notice of charges, an administrative hearing before an immigration judge, the opportunity to apply for asylum or other forms of relief, and judicial review of their case. The Alien Enemies Act, by contrast, authorizes a very summary process in these sorts of emergency situations. Now, the Alien Enemies Act does include at least a rudimentary hearing mechanism. It states that courts could contemplate complaints that might be filed against particular alien enemies who are violating restrictions or deemed dangerous after a full examination and hearing. So in practice, during World War I, World War II, That was a very perfunctory sort of process. Many alien enemies were detained usually based on nationality and alleged risk, no sort of individualized guilt findings or evidence, especially right after Pearl Harbor, when hundreds of Japanese, Germans, and Italian aliens on the West Coast were rounded up without any sort of traditional hearing. Now, President Trump, in some ways, short-circuits usual due process that we would think about this. His proclamation, his executive order, was to immediately detain and remove certain non-citizens, members of a Venezuelan gang, as enemy invaders. So this is essentially an executive determination. They found a level of dangerousness as applied to a whole class of individuals with no case-by-case adjudication of each person's culpability. And the administration's position, President Trump's position, is that in an emergency, the president's powers under the act override the need for individualized hearings. And officials have argued that requiring the usual immigration procedures would usurp the president's core authority under the act. So let's be frank here. There's a lot of ambiguity about what level of due process would be required here. In American law, even in wartime emergencies, the measures have to still adhere to the Constitution. An executive order or emergency declaration can't simply nullify the Fifth Amendment's guarantee of due process. However, what process is due is the rub, and that's highly flexible in extraordinary circumstances. Courts have balanced individual rights against compelling national security concerns time and time again. During actual wars, courts have tolerated or streamlined draconian measures that would never be accepted during peacetime. We can think of Korematsu, a case that upheld the exclusion of Japanese Americans from the West Coast, effectively countenancing a race-based curfew and internment policy that has later been heavily criticized. Now, we've had a good deal of a judicial revolution since World War II. The post-civil rights revolution has reshaped constitutional law, and what may have passed as due process or weighing of national security concerns versus due process concerns in 1948 probably looks remarkably different in 2025. How different remains to be seen. I think it's fair to say, if we're examining the point from those challenging this deportation, that courts are now probably more likely to insist that even non-citizens have some baseline of a fair procedure, especially if they have significant ties to the United States. For example, a federal court in 1979 said that the executive, even in the area of immigration and naturalization, must be subject to the principles of the Constitution. In that case, Judge Joyce Hens Green found that targeting certain Iranian students for special registration and deportation violated equal protection and fundamental fairness promised under the Constitution because it created an arbitrary classification with no individualized suspicion against the students. But let me tell you, that ruling was later overturned by the D.C. Circuit. I raised the earlier Iranian student example because similar arguments are being made today with Trump's 2025 alien enemies deportation. Sudden group-based deportations might violate the Fifth Amendment. And do there have to be individualized suspicions against particular actors? Or does the executive have the power to deport these individuals en masse? And what level does court oversight have in all of this? So whether an emergency proclamation and executive order can override normal notions of due process, it's a matter of degree and judicial perception. If courts accept that an actual invasion is underway, and if the executive, if President Trump can put on that evidence, the courts would probably allow extraordinary measures and postpone rigorous judicial review, effectively giving the Trump administration a temporary pass on usual procedures. If courts view this skeptically, if the evidence put on by the administration doesn't show an emergency, doesn't show the sort of incursion contemplated by the act, then I think courts are going to be more willing to give weight to due process concerns. They're going to require more lengthy judicial review, administrative oversight, the ability to challenge evidence that's put on, and provide for that pathway forward. Overall, it's the initial burden on the Trump administration side to show that this is a real national security, one that's contemplated under the Alien Enemies Act, and that he had to act now. If he can trigger that sort of resonating doctrine in the court, they're going to defer to the immigration and deportation considerations of the executive. So what I'd say initially early on in looking at this is that if courts start to be suspicious about these powers, if they don't fully buy into the evidence that's been put on by the executive, then they might impose a few restraints on how the Trump administration carries this out. What might those look like, the remedies? Well, you might see the requirement for individualized hearings, no mass 300-member immediate removal. Case by case, each individual being able to challenge the evidence of ties to criminal gangs and the like, the same as we might expect for anyone else, meaning thorough and adequate judicial review. We would see a requirement that asylum claims be examined. We have statutory obligations to recognize asylum claims and the threat of an individual being hurt, killed, damaged, being sent back to a home country, or in this case to El Salvador, or a third-party country, might raise those concerns. The courts might also ask for there's more clarity about exactly who's a dangerous enemy, what's this predatory incursion, what is the scope and limit of that, so that when the executive acts, that they're only acting in a very narrow way, in an exceptional way, and that's defined, and that it can be controlled, rather than that this is some sort of an expansive power that the administration can use at its own whim. Let's make this just a little more complex. President Trump is using the law in a novel way to go after members of a transnational criminal syndicate, Venezuelan crime organizations, as well as MS-13. And it's the first time that the act has been used against a non-state group, a gang, rather than a nation's citizens in general. This is novel as well in terms of how courts have to define the statutory language. Now, at the beginning, I went back and imagined some founding era comparisons. Piracy, Indian or Native American incursions. And so there is some flexibility, some leeway that the administration might be able to use this to be able to extend to violent criminal members, assuming they've got some evidence, and I think they do, supporting these claims. What do we know about these gangs? Well, MS-13 are brutal killers. They use machetes. They're responsible for human trafficking. And there's a long detail this from the 1980s going forward. We haven't been able to stop them. Now, Venezuelan gangs are implicated too. They're newer to the American scene compared to MS-13, but they've been linked to murders, to arms trafficking into the United States, and to exploiting migrants to be able to come over. Again, human trafficking. So these actions seem to target some of the worst actors internationally that we haven't been able to stop. Now, I'd like to examine how a few other presidents have used similar powers. Now, again, we have a limited historical record here, so we only have 3 examples of use of this. And the one that I mentioned that is probably most powerful for the Trump administration was the Truman administration's use of it during a non-war period. But let's look at how other presidents have used the power of the executive to enact emergency powers in the area of deportation or in immigration, because I think that helps us understand just how far-reaching this might be. And part of this is understanding the exact power of the executive, which is itself a complicated and vague, open-ended area of law. Let's go to the Carter-era Iranian crisis. So this was not under the Alien Enemies Act, but it's analogous to the present situation because President Carter ordered Iranian students in the U.S. to report for visa checks, and those found out of status were targeted for immediate deportation. So this was a nationality-specific crackdown in response to Iran's hostage-taking of Americans at the time. The initial result was a court injunction at the D.C. District Court. Sound familiar? Halting the program is unconstitutional discrimination under equal protection grounds. But the D.C. Circuit reversed the decision and effectively reinstated President Carter's program. The D.C. Circuit held that nationality-based distinctions are allowed in immigration and deportation so long as they're not wholly irrational. And it stressed judicial deference was the norm for the president in foreign affairs. And this appeals panel famously said it's not the business of courts to pass judgment on decisions of the president in the field of foreign policy. That's pretty strong precedent. Now, if you've been on my channel, you'll remember we discussed the Trump v. Hawaii case during my TikTok walkabout in New York. And there, the Trump administration, in his first administration, had banned travel from several majority Muslim countries. And that was started in the District of Hawaii and went forward. But the court applied a highly deferential standard, refusing to second-guess the president's asserted security rationale. It found the policy was not irrational on its face, despite its broad sweep. I emphasize the word irrational because that means rational basis review. We've talked about levels of judicial deference in the past, strict scrutiny being very difficult for government to prove, but rational basis is very low. So long as you can find a plausible, non-discriminatory purpose for why an act might be in place, the courts are going to uphold it. So, like the other cases, the Hawaii case signals that when national origin actions are tied to national security, and there's at least some evidence to support that, courts will give the executive the benefit of the doubt. Not always unanimously, and not without concern for bad faith actions by a president. Franklin Roosevelt used emergency powers to be able to control immigration and deportation as well. It's one of the most dramatic examples. In response to perceived spying and sabotage threats after Pearl Harbor, he issued an executive order that authorized the military to establish exclusion zones and remove any persons deemed a danger. It led to forced internment of Japanese Americans and several thousands of resident alien enemies of other national origin descent. And you'll remember that in Korematsu, the Supreme Court deferred to that power. And when the judiciary would be examining the power of the executive, that the executive had wide latitude and the judiciary would have very high deference to those decisions made. Now, Korematsu is highly criticized today due to the errors made in it. Even before Pearl Harbor, President Roosevelt froze German and Italian assets in the U.S. under Trading with the Enemy Act. And after declaring war, he authorized seizure of foreign-owned businesses and property that were deemed vital to the war effort. And his actions were upheld as being within Congress's authorized wartime measures. I mentioned President Truman earlier, and that was the instance where he kept a German foreign national in custody for years after combat ended and the wars were over, and the court upheld the use of that power, again, through deference. President Truman, besides dealing with German foreign nationals and having that upheld, went a step too far, and that's the famous Youngstown case. You study it in law school because it defines the scope of executive authority. And he tried to seize America's steel mills, but the Supreme Court decided that was too far outside of his power. Youngstown's a landmark reminder that not all emergency actions are actually permitted, especially if they lack a statutory footing and they encroach on civil rights. Though the case wasn't about immigration, it does underscore that courts do serve as a check to executive power when it strays beyond its limits. Other presidents have relied on emergency powers too. President Reagan sanctioned and froze the assets of countries like Libya after we had terrorist incidents, and Nicaragua as well. He ramped up enforcement on the border against drug traffickers as part of the war on drugs, and deployed National Guard and military assets for surveillance with Congress's approval. We know that President Bill Clinton had anti-terrorism measures just the same. So in 1993, we had the World Trade Center bombing, and that prompted Clinton to use emergency powers on a smaller scale. He allowed the preventive detention and removal of alien terrorists, including the use of classified evidence in immigration courts. He invoked federal law to freeze the assets of groups like Al-Qaeda and other terrorist entities. President George W. Bush, after 9/11, used some of the most sweeping use of emergency powers since World War II. Although not directly related to the Alien Enemies Act, they're instructive precedents and acts. He declared a national emergency and obtained congressional authorization to use military force against those responsible. He detained over 1,200 foreign nationals in the weeks after 9/11 for immigration violations. Many of these cases were held with closed hearings, a practice that was later criticized. Bush also implemented a special registration program requiring male visitors from dozens of predominantly Muslim countries to register with authorities, echoing the Carter approach, but on a larger scale. Bush's measures faced some legal challenges, but courts, again, largely deferred, citing the plenary power in immigration and the need to prevent terrorism, a power that is entrusted wholly to the executive. President Obama took a different track after 9/11, and he did use executive orders to sanction transnational criminal organizations. So we have a parallel to what President Trump is doing here. It sets a precedent for treating non-state groups as national security targets. So from both history and from judicial precedent, a few themes emerge. Presidents often act decisively when they perceive a national emergency, and sometimes they act very sweepingly against those who are perceived as enemies or threats, and they use whatever legal tools are available: war powers, immigration powers, economic sanctions, seizing of assets. Courts generally give presidents wide berth when the threat is external or related to foreign affairs. However, when it is targeted within U.S. soil and we deprive individuals of liberty, property, or process, courts usually demand some level of justification and procedural regularity. President Carter's deportation of Iranian students is, I think, instructive precedent for Trump's case. It shows that even in a fervent crisis, a blanket policy will be tested in court. And in the past, deferential review has been the standard, essentially a rubber stamp, when these sorts of declarations are made in a good faith effort by the executive. We know that the Carter deportation issue was upheld by the D.C. Circuit. The Supreme Court passed review on that, and the balancing of the executive's foreign policy judgment against the constitutional promise of equal protection simply deferred to the concerns of President Carter. At the end of the day, it was a narrowly focused provision and temporarily tied to a specific diplomatic crisis. Assuming President Trump can make the same argument, that there's a particular temporary crisis that's going on with transnational criminal gangs that we don't seem to have control over, under the Carter precedent, is likely to be upheld. One thing that's noteworthy, too, when we think about this, is that the history is clearly on President Trump's side, that courts will defer to the executive when acting in this way with emergency powers. That's in the short term, but in the long term, presidential powers are usually judged by courts and history. FDR's internment decision, one that was thoroughly backed by the courts, is now viewed largely as a grave injustice. It's led to reparations and apologies decades later. Carter's hard line on Iranian students is largely forgotten about today. It's overshadowed by the fact that cooler heads prevailed and many of those students stayed and became Americans. President Trump's use of emergency powers to deport criminal aliens is part of a long lineage of assertive executive actions against perceived enemies within. The legality of these actions has always been contested. It balances fundamental security concerns of the utmost highest order versus liberty and due process concerns of individuals. In all of this, I'd just like to be very clear, because I am a constitutional litigator, and I in no way support stripping of due process during ordinary times or for ordinary measures. But I want to give you, as just to be a straight shooter with you, a plain reading of the history and nature of these sorts of challenges in the courts. Courts have been exceedingly reluctant to second-guess the president over any sort of a war power. An immigration law doctrine, the plenary power doctrine, we discussed that in the Khalil video, also leans towards judicial hands-off approach. Courts have upheld even sweeping nationality-based measures, like banning entry from certain countries, as long as they can be tied to some legitimate, some rational security reason. In immigration and deportation matters, the Supreme Court has repeatedly held a simple truth that the political branches have paramount power. For example, in Fialo v. Bell in the 1970s, the court called the power over immigration largely immune from judicial control. And in Trump v. Hawaii, more recently, the court deferred once again to the president's determination of detriment to U.S. interests by those traveling from majority Muslim countries to the United States. If the deferential stance is applied here, and history suggests it will be, one could conclude that President Trump's actions, however aggressive, fall within the legitimate scope of policy choices that he's entrusted with. After all, those who he's targeted are, by the administration's account, non-U.S. citizens with no lawful status, with criminal backgrounds, who are injuring Americans. In the sense, the president is not claiming a power to deport someone whom the law would otherwise allow to stay, but he's claiming a faster, more unilateral method to achieve removals that Congress itself would likely support. And let's remember, the D.C. Circuit overturning the D.C. District in the Carter era affirmed that making distinctions between classes of aliens for expulsion is permitted if based solely on some rational basis for foreign policy. So labeling a foreign gang as an enemy probably meets the rational basis test. It's not wholly irrational to view a foreign organization that is a violent gang as a security threat, and a court inclined to defer could uphold Trump's use of the Alien Enemies Act as lawful, if somewhat extreme, a tool that Congress itself provided, with the understanding that presidents must act quickly and decisively to protect the nation from foreign threats. That is the role, that is the province of the executive. Now, I don't think that President Trump gets a blank check here. There are weighty constitutional concerns that cut against any sort of unfettered power that the administration might have. The lack of a formal war or clearly defined foreign adversary is important here. Judiciary might decide that in absence of any sort of congressional authorization or speaking on this matter, that there are more limitations to his power. And as we've discussed in due process earlier, it may decide that more individualized determinations are needed here. This has simply gone too far. It's also novel that President Trump is the first president using this outside of the wartime context. He has, in my estimation, a strong statutory basis for doing so, looking at the incursions language at the end of the Alien Enemies Act. But this is wholly new and is going to be tested in court. We also have to do a little bit of crystal ball reading here. Chief Justice Roberts wrote in Trump v. Hawaii that Korematsu was gravely wrong in the day it was decided. So due process norms that we examined in the 1940s and 1950s have seen an expansion. There's greater liberality given to them. So how that weighs in is certainly unknown as well. Other arguments that favor the detainees and individuals being deported, courts could say that Congress has spoken authoritatively against this power since 1798 through our provisions on asylum and through our generation of a large statutory framework about deportation, that those speak conclusively to the issue and not this emergency power. That remains to be seen, what weight courts will give to those countervailing concerns. Maybe Justice Jackson got it best in Youngstown and noted that the president is not a lawmaker. His power is at its lowest ebb when he acts contrary to implied congressional intent. But if we look at the lay of the land today, we have an authorized act of Congress, the Alien Enemies Act, still good law on the books, and is using it seemingly in pursuit of a venture identified in the very language of the statute, these enemy incursions. Certainly President Trump's use of the Alien Enemies Act pushes the envelope of immigration and executive power. And this is an administration that's testing the boundaries. We've seen several presidents in our past do the same. And it will be an interesting era in our history as we further define exactly what the scope of executive power is and how that weighs against the constitutional rule of law issues I've discussed. I think it's fair to call this legally a close call. The case will likely turn on nuances of statutory interpretation, for many of you, boring, and a judiciary's willingness to extend what we usually think of as wartime deference to unprecedented peacetime scenario, but one that fits comfortably within the statutory provisions for invoking it. Presidents do receive great deference in matters of immigration and deportation, but that deference does have an end. It's not unlimited. It's bounded by the Constitution and the factual realities of the situation. And here, the critical constitutional concern is due process and serving a critical counterweight here. My suspicion, if I had to guess, I don't have all the evidence in front of me, I don't have a thorough record. My suspicion is that if anything happens from the judges, is that some minor change to requiring better protection of due process rights here might be imposed. I think that we've seen from history that the deference that we've spoken of here and in other videos will carry over into this case and will give President Trump great room to be able to exercise here. Might we see mild add-ons for due process concerns that I noted at the front, individualized hearings, a better ability to confront evidence? Possibly so, but I suspect those will be minor setbacks, not major ones for the administration. Justice Sandra Day O'Connor wrote in Hamdi that a state of war is not a blank check for the president. The same holds true for a state of emergency. The Alien Enemies Act gives the president a check, but not necessarily a blank one. And that's what the courts will wrestle with. This isn't an easy decision for any judge to be able to have to review. The president takes a lead role in protecting our nation, and judges probably rightfully defer in these use of these extraordinary powers. Courts have to scrutinize these claims of due process as well as the evidence put on by the current administration of this incursion by foreign transnational criminal syndicates. As I noted at the beginning, if we read history, if we read our precedent and we put it all together, I think the Constitution likely has to say to these deportees, adios, muchachos. I'm going to put on an ask here at the end. If you like the content we're making, it sure would benefit us if you like and subscribe so we can continue producing more worthwhile content for everyone. That's it this week. We're going to have another short video coming up on how a Supreme Court case is made. I'm working on one right now. I thought it'd be fun to bring you, the viewer, into that and to see what the considerations are and how we develop this, exactly how the sausage is made. Until next video.